1 trillion rupiah, and they are stopped by 2 people. Yes, they are doing a criminal act, and they are enriching themselves. But is that a corruption? No, but this is only a theft. And corrective criminal resuscitative, we also have this. Corrective is the follow the suspect, so you go after the suspect, but in finding, in this case you can use restorative, and in the middle there is this rehabilitative, to rehabilitate the name of the person, and the return of the financial state finance, and we insert the law number 32. If in there is the financial loss, then not always the state finance loss is because of the corruption, and it can also hold double offset to deliberate actions. There should be meeting of mind between perpetrators. They do this deliberately. Professor Mulyatno made this. It has to be so there should be the same things done by the perpetrators, and there should be subjective. There should be meeting of mind. There should be agreement to fulfill the criminal action, and it has to be applied in Indonesian Penal Code and CPI, CE. So this is meeting of mind, and he was telling about the example about the meeting of mind, and personal corrupt is when there is no statement. Article 64 for theft from Penal Code, I will repeat that. Article 64, there is an action that is a similar action that is done continuously, and this can be illustrated. A will construct a house, and today he steals bricks, tomorrow he steals something. So there is a continuation, and there is no meeting of mind, for example, or deliberate cooperation, and type of this meeting of mind. So the deliberation as an intention, deliberation as a possibility, and there are 6 types of this. There are 5, and 2 are actually the reasons to forgive. And the second article do not mention about the deliberation. And then when we go back to doctrines, then otherwise you have to and then the underline, you have to law number 32/1999. Prosecutors said that if it is very clear that there is the state loss, and you can bring the evidence to the AGO or to the competent institution to file a claim, and there is a law about the special and specific, material and formal. So the decision of the special court has so if it is in violation of the formal thing, so prosecutors are restricted now. They're only dealing with violation of formal laws, so not about and this has been set by regulation and criminal context. If there is obligation that is not done, it is normal, because this is related to the existence of action, then we can do pro justicia investigation, and the testimony of the witness can be included in the proceeding. If it is not according to the method, then you don't have to consider it. And responses from the defendants, no objection. Denis Dorsano, SKK, expert, he's one of the deputy at the BPKP, the authority, since his authority is to do all the examination toward state finance, and the authority is to conduct audit by BPKP, but this has been revoked. And there is the central level of BPKP, and then provincial level, and also the district level. And based on law number 15/2006, BPK have to do the audit, and how auditors find something, then compare it with the actual condition. If they do this, then they will use the standards of the experts. And the first one, standard, the general standard, and then reporting standard, and BPKP and Supreme Court have entered into an agreement that regulates the possibility to do joint investigation to calculate the state loss. And when they are doing this, this can be done if necessary. And auditors have to, I will repeat, auditors have to be confident in this while building communication with the relevant parties. No objections. 7. Dr. Insinyur Gunawan, MSc. He only knew but the reduction of the TPH biotechnology is a technology that benefits from microorganisms to make the land fertile, for example. And bioremediation is to use microorganisms to take out the contaminants in the land. And this is a testing. So before you give fertilizer that is effective, and there are several type of testings, biological testing, to see microorganism survive or that or not. TPH, also activity of the and then living organism, and then biological testing, and also to find the microorganism and activity, and also the standards for comparison. So there is before doing the testing, it has to be stored well. The handling is done in the lab, and the location, it has to be done in the dimension that has been known before according to the objective of the research. And the land is plowed and then watered. And to know whether the work has been correct or not, there should be a license. So the treatment and addition of fertilizer, it has to be calculated very carefully. And the microorganism will grow, and the ratio has been determined. CP ratio is 1 to 100 to 1 to 200, and this is relative. If CN is high, then the reaction will be very slow, and you can add the fertilizer, so it will be 1 to 10, then it will be a good ratio. And also you have phosphor in the land. If the amount is done, then we apply the same formula, and then otherwise we multiply it for phosphor. Analysis can be done at the beginning as long as the pH or TPH comes from the same source, and the content of TPH does not change quickly. Otherwise, it cannot be then the sources for waste. And this is under the ministerial decree of environment. because there was already a bacteria and there was no food, then they will work very slowly. And the sources for contamination, if it is not clear why it was contaminated, then it needs to be analysis first. And this is a test that is not very careful. Microorganism in bioorganism, the most important thing is the amount of the food, and it has to be heterogeneous, and pH is not necessary because there is no standard for this microorganism that is used. It can be fungi, plants, but fungi or fungi, you have to do testing and using a lot of pollutants, and bacteria cannot grow. And it cannot degrade the toxic. And for CNP, this is the same. And you will waste a lot of cost. CNP for all microorganisms that exist, and microorganism can not all microorganisms can react to fertilizer, and this is related to the land. If the texture of the land is very smooth, then the dilution will be easier, and dilution thickness can be adjusted. And no objection. Dr. Mojakir, SMA. Pali is the lecturer at the Faculty of Law, University of Indonesia. Should open for this article already involves all actions that is related to state laws, and that is the third article of TPK law, and it can also happen and related to the domain of criminal law. And the formula said that this is a corruption crime. Toward Article 2 and 3 from anti-corruption law as state laws, the law, if the law, the relevant law has to comply, and in the event of corruption, then this law should be effective, because there is no mandate from the anti-corruption law. So there are two other legal arguments should there be any other action that is not related to Article 14 from the anti-corruption law, or the law will be adjusted to the relevant law. And from the there's also another regulation, another law, and there is a sanction. So they comply with the contracts, and that is also related to the. So if there is an intention to conduct a bad action, and this is related to penal code, there is a interrelation between this and another. So to fulfill the elements of these articles, and the first, there should be a material first, and there's. And considering no objections from the defendants. First, whether the defendant is in the healthy condition. Defendant it's not clear, sorry.
Where does the where do you know? He didn't answer the question. Do you, in the process of tender, in the pro-qualification, he didn't answer the question and about the types of work, he didn't answer a question. In terms of the offer, do they use sampling procedures? He didn't answer the question. How much was the offered? He didn't answer the question. Does FGJ has the permit from KLH to have to hold the? He didn't answer the question. So, when are you considered as the winner, chosen as the winner, and who actually determined the winner? He didn't answer the question. He didn't answer questions. He didn't answer the questions about the work and the value of the contract. He didn't answer whether he knew the witnesses. He didn't answer a question whether he had relation with the people involved in the contract. As a witness, he didn't answer the question. And in the question whether to whom he is responsible to answer his work, he doesn't give the question. He doesn't answer. And on the question whether when the project is finished, and he didn't answer the question. And about the mechanism based on the contract between CPI and the company, he didn't answer the question. He didn't answer the question. He didn't answer the question about payment of contract. He didn't answer a question about whether the company has received payment in relation to the contract of 7861 and how much that has been paid and in what currency. He didn't answer the question. And he didn't answer a question about the evidence and whether he would come back to the next proceeding. He didn't answer the question. And whether there was he wanted to be explain more about the proceeding. He didn't answer the question. The defendant refused to use his rights to answer. Then the judges had already given the defendant the opportunity to answer the questions, but he remained silent. Then the hearing continued when the prosecutors actually expressed these questions, considering that in the proceedings, all the evidence have been shown to the defendants in the form of letters that it would be which is from number 1 to 11, and then evidence code B, C, D, E, F, G, H, I, and J. All of which are complete in the decision and have been recorded. To all these letters and evidence, the defendant claimed that he knew. Considering that to summarize all the explanation, so everything that actually takes place in the proceeding, that is mentioned in the proceeding, that is considered to be used in the proceeding. Considering all the evidence that had been mentioned had been confiscated, now it has been used as evidence. considering that the letters have been read, that in the list that the defendant in his note of defense. Okay. And continue. It will be continued by one of the judges. FEG 02, SGJ in terms of preliminary mobilization, SGJ 04 in biomediation, then documents of payment of salary, invoices, and data on the law on BPK and BPKP. The evidence on the proof of work has been done. He's mentioned all the proofs of work that has been done, has been one. Second is the suspend of the set off the cost recovery of biomediation. Third is a certificate of biomediation. SGJ 15 list of listing that has been confiscated. Considering that the defendant has been brought to the court with charges with the law number 18 on the on corruption law. Sorry.
Amendment of law number 31 in conjunction with and considering about the Criminal Act and also the school code or legitimate onto the reckoning on the defendant is going to be considered as follows. Defendant is brought to the court with the subsidiarity allegation, so the panel of judges will consider indictment. First, the primary indictment is he violated the law about corruption law, as has been amended by law number 21 of the amendments of law number 31 and about eradication of corruption. Yunto, Article 64, the first paragraph that explains about the following elements. The action against violation, and then bring state laws and forth together to conduct a criminal act and also continuous act. And considering that the panel has to review the opinions and also testimony and also the prosecutors in the indictment, and together with the responses and prosecutors to conclude that the terms in each of the Article 2, Article 3 about the UPTK, that's the corruption, this is the principle of corruption, and according to the panel, this is not accurate because in the criminal law, it is also valid for all the actions under other laws are also deemed as criminals. So this is also included as this corruption eradication, and under Article Article 1st out of paragraph 1, and before the action is done, and this is actually only for an action and also behavior and all the things which are alleged. If the regulation is violated and there is no prohibition for the perpetrator to do this. However, it is admitted that between criminal action, this is inseparable because, but you have to know that the criminal has to be addressed to a person. So human is not the element of anything. So this is just a legal subject that's alleged by, and this is addressed to Herland Bin Ompo as the director of Sumigita, with the identity, complete identity included in this verdict. And he, during the hearings, he answered all the questions, and also provided his knowledge, and that shows that he knows the difference between good actions and bad actions, and also know the difference. So he is in a healthy condition. He doesn't have any psychological or mental disturbance. So there is no conflicting ground in the sense that there is excuse to waive him or release him from all the criminals. And considering the examination during the hearings as the legitimate testimony, he did not want to answer the questions from prosecutors because he said that he was not given the opportunity to bring witnesses that was already given to prosecutors. And before Hotman Pedesitompo walked out from the hearing, when the expert witness by prosecutors was here to be heard of his testimony, and the second one, Hotman Pedesitompo, and legal counsels also walked out. And toward this event, the panel of judges are in the opinion that, according to Article 16, is not charged of right of incrimination, and therefore it is okay if he is not cooperative, or he did not answer questions, or if he committed a lie, he didn't have any burden of proof. And the prosecutors is one of the agent of the state agency that is doing prosecution. Therefore, the defendant and also legal counsel do not have burden of proof, but then the evidence has to be supported to and based on the considerations, and based on the consideration, the judge can accept the other charge witness. And during the hearings, and before the decision that was already made by the panel of judges, the second, the walking out of the legal counsel from the hearings to accompany the defendant and also to look at the truth. And according to the criminal law, the hearing was done orally, and it could be understood by the defendant. And the walkout of the legal counsel was against the public order in the hearings as set forth by our penal code or criminal procedure law. And therefore, the defendant, as the director of the Sumigita, and the primary elements were going to be considered: the act against law or unlawful act, and the law number 31, 1991, it was mentioned that unlawful act include unlawful act in formal and material way, although the act is considered as unlawful because it doesn't comply with the social norms, then those actions can be criminalized. And considering that the unlawful act with Rasukrat decision 31st of January 1999, so to do do positive act and negative act that is in violence with the laws, and also the ethics and norms in the society, and that is according to the law number 31 about corruption eradication, and that is to evaluate the law. And considering with the Constitutional Court decision 003 of Roman 4, 25th of July 2006, it said that the unlawful action that is against violating formal regulation, this, and also the decision from the Supreme Court of Indonesia, that is the Supreme Court of Indonesia, and the element of violation of law in the penal code of Indonesia is like another code, civil code, and this is objective on recht aanwend, and this is the element of criminal act which is separated from the nature to go against the subjective law as one of the elements of guilt. In the doctrine or criminal law doctrines, it is mentioned, as mentioned by Helen and Mayer, page 2 in one book. So unlawful action can be of several types against others people's right or without own rights. Professor Omar Sanati said that the first type is actually the same like violation in civil law, and in the civil law, this is according to the decency principles, the norms that live in the society, and also the material, and that is the basis to interpret this and look at the lectures of compilation of lectures and violation of law, as mentioned by this doctrine, is the same like Indonesian jurisprudence that construe the violation of law is as like violating normal and normative, and this is law, and this is confirmed by the following cases. Aras Natanagawa said that it's not right that to violate law, then according to the development in law, it has to be measured using the decency principles in the society. And the decision of the Supreme Court 6 June in Indonesia, so to violate a law is to go against the material laws, and it includes the justice, the sense of justice, especially in the sense of unlawful actions, and also corruptive actions that are related to legislation, and also related to indecent action that is against the norms in the society. And the decision of the Supreme Court is in line with the strategy and the politics of law that wants the total law enforcement with the basis of the mindset in the context of preventive and repressive effort, because we know that corruption is a systematic crime that can distort all the elements of the state life, especially in terms of revenue of the state, and this can be seen in the decision of Supreme Court PTS 2009, 18 August 2009. And then the definition of a violation of law as is set forth in law number and the corruption, it can apply to this defendant's case. And because of the nature of the unlawful action, based on the witnesses, Susana Ademulio, he said that he didn't know that he is the procurement committee for the related procurement project, and he just knew when he was asked by the AGO for his testimony, and he did not have the certification from BP Migas, and for the procurement project he didn't know anything about this because he was not involved in the procurement process. And related to the documents that he signed in his capacity at the time at the reliability engineering and maintenance rep manager, and one of which proposed the remediation process, and he also knew about the memorandum of dated 28 May about the replacement of procurement committee's member for the contract because the procurement committee before were not certified. And Saksi Suri, witness Suri, oil sector in Indonesia, which was controlled by BP Migas, or its witness Suryadi mentioned that he is the new procurement committee member based on the memorandum dated to the 22nd of May 2008 about replacement of member of procurement committee for contract for the project of remediation. That assignment as for his assignment as the head of the procurement committee is based on this document on the 28th of May, and he did not do the process from the beginning because from the beginning for this contract it was done by the previous procurement committee number bid plan in September 2007, and the reasons for the issuance of the memorandum DPU slash 22nd of May 2008, which was valid from 2008 May. This was referred to in this document dated 9th of June 2004. The first chapter which says that the head and the members have to be undergoing training and have to be certified by BP Migas or other institutions appointed by BP Migas. And according to witness, each of the procurement committee before was not certified, and the witness signed a proceeding that included the implementation of the bidding 31st of March 2008, which was given by the Suradi, which assisted, and he was the secretary of the old committee, and the witness was appointed 22nd of May as the head of the procurement committee for contract 760K to replace the old committee, and he signed the proceeding on the 31st of March 2008, and witness did not have any motivation for the signing of this document, and I was just doing the administrative requirement. I didn't know the phases of the bidding, whether it was already done according to the proceeding that he signed, and the old committee knew about this. He just inspected the documents. Another witness said that he was not involved in the remediation work, but was just the secretary of the procurement committee to conduct the services for remediation. Contract number C 956 C 905 taking place in Chevron Pacific Indonesia in Rumbai, Pekanbaru, Riau. And the basis for his knowledge for doing this work, according to, and that was already approved by manager of contract and category management of the new one, that is Bagawan Isa Wahyudi. For Saksi witness Yohanes Wijanato explained as follows: the procurement committee had to have procurement certification for the procurement project that has already done by the committee, and the new committee cannot use the results from the old uncertified committee. So if it has already Jody Putrato explained that he approved to issue to name Sumigita as the winner based on the confirmation letter, and the basis is because of the legal opinion that from CPI that the process for procurement is already in compliance with the regulation, so it can be used by the procurement committee as a basis to continue the procurement process. It was already determined by the old committee. There was also a guarantee from Vice President of Chevron Pacific Indonesia. There was already a proper process. There was one of the asset managers. Sumigita is a provider service for construction, including civil work, land work, and also excavating and electrical work. Sumigita Jaya does not have their own laboratorium for bioremediation. Sidahuruk explained that he, as an expert or quality analyst or quality control of SGJ, he is not bioremediation expert because she is a expert worker working at the CPI, because she was trained before about bioremediation in Bandung, which was conducted by PTCO, an event organizer for training lasting 1 week, with the instructor coming from ITB. And Sumigita does not have an equipment for doing microbe testing and land testing, soil testing, so he just assigned this to the microbiology lab at Rio University, and they did it starting from 2011. CPI had the lab for measuring the TPH, but Sumigita did not have the lab, and during this bioremediation work, they never did the testing about the bacteria types and also the bacteria that is there in COCS, because it's not governed by the contract. But Isidro asked the lab of Rio University just to know whether there are certain bacteria in the COCS that is going to be treated. About the type and an amount, no testing was done by Sumigita. And Sudolete Hotahuruk also mentioned that the treatment towards COCS is not the same to set up the formula, and if, say for example, COCS, if there is contamination, the treatment is the same, but this is binding on the SOP, and also for the cycle, and also to determine the amount of fertilizer, it depends on the microbe amount, and if you refer only TPH content, then you do the processing in processing pit in Minas. The director of Sumigita also knows that Sumigita just did the mixing of composites using stabilizer up until they are homogeneous, and sample is taken to be taken to the lab by CPI, and the results of the lab from CPI with the formula of fertilizer, and then fertilizer adding is given, and COCS treatment is done twice by giving nutrients to the COCS that is treated, and fertilizer, so urea and CPP, because it's according to this standard operational procedure, and the procedure has been determined by CPI, and this work, excavation, and also the measuring of TPH has been done by Sumigita regularly every 3 months and 4 months until the level is below 1%. Mastati Hilman, the witness, mentioned that she has someone from the KLH. The reference in his division in doing her work is law number 32, 2009, government regulation number 19, 2009, and also the ministerial decree of KLH, and also number 18 about the analysis. KLH has never issued license for Sumigita, because the license to do bioremediation is only given to CPI, and this is the decree that is valid to March 2009, and for 5 SDS Minas. For 5F SBS, and also the decree from LH 27 February for 1 SBF in Kota Bata, and licenses are the licenses that are applied by the producers and also the treater of the waste, and this includes the type of the waste and also amount of waste, and this is not separated from the license. And according to the regulation, there should be a lab and also expert. The witness does not know about the expert at Sumigita, and license is given to the producer that treats their own waste. But if the waste is outside the location, then there should be another application of license. And when the witness was